You tune into the Four Boxes Diner Second Amendment channel because you want to learn things maybe you don't hear anywhere else. Well, today is going to be one of those days where you hear something that you've heard about in other contexts, but almost certainly not in the context of our right to keep and bear arms. That is something known as institutional reform litigation, and how this can be used against those that will deprive us of our rights. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Okay folks, there's something called institutional reform litigation. Institutional reform litigation, which means what? It's just what it says. You use litigation, which means federal lawsuits, to reform or change an institution. And you're like, Mark, why on earth do I care about institutional reform litigation? I've never heard of this. What are you talking about? Well, here's a new idea I've come up with. I'm not aware of anybody else who's come up with this idea in the context of the Second Amendment. Maybe they have. I'm just not aware of it. But here's the idea, nonetheless, I want to run by you. I'm actually thinking about maybe even doing an article and writing this up for the Second Amendment movement. I'm thinking about it. Here's the idea. Over the last many decades, there have been lawsuits brought, civil lawsuits brought, all across America in federal courts. And in multiple instances, many instances, in places like Kansas City, Missouri, for example, federal courts, federal judges, have effectively taken over, using their inherent equitable authority, their inherent power, all sorts of institutions all across America. School districts in places like Kansas City, Missouri. Prisons that are being run unconstitutionally, improperly. And other government organizations have been taken over by courts. And even if you think about it, in the context of bankruptcy cases, the court effectively is overseeing a bankrupt entity and monitoring it. And most of the activities done by a bankrupt entity have to be run by a court before they can be approved. So where am I going with this? Well, as I see it, one of the questions I frequently get asked is, Mark, these anti-gun states, the usual nanny states, we know who they are. New York, New Jersey, California, Hawaii, Massachusetts, Maryland, etc., etc. These states are always looking to hurt American gun owners, as I see it. They're notoriously bad on gun rights, and people have understood this for quite some time. Now, keep in mind that in NYSERDA versus Bruen, the U.S. Supreme Court said that, for the moment at least, shall-issue licensing regimes are acceptable. Now, they said this in what's known as dicta, because it was not an essential component to the holding. The critical decision in NYSERDA versus Bruen was, of course, that we all have the fundamental constitutional Second Amendment right to have firearms that we get to carry outside the home in public, loaded in anticipation of self-defense. That was the holding of Bruen. And on a related note, they articulated the proper methodology for analyzing Second Amendment cases. Those were the two key holdings, if you will, of NYSERDA versus Bruen. But they said a lot of other things, much of which is called dicta, which means things that are not officially binding on the world, but are helpful for people to guide their behavior going forward as to kind of how the Supreme Court sees the lay of the land. And in that decision, they basically said, for the moment at least, they don't really want to see any constitutional challenges to shall-issue carry regimes. They have no issues, of course, with permitless carry, constitutional carry, that's fine. And for the moment, they have no problem with shall-issue carry regimes, provided that those shall-issue carry regimes are narrowly focused and objective and not subjective, among other things. Okay, the reason why I bring this up now is that also in a footnote, I believe it's footnote 9, the Supreme Court specifically said that, as I turn my attention to footnote 9, quote, because any permitting scheme can be put toward abusive ends, we, that's the majority of the Supreme Court, this is the court's opinion, we, the Supreme Court, do not rule out constitutional challenges to shall issue regimes where, for example, just an example, these are examples, not the only way, examples, where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry, period, close quote. That's what the Supreme Court said. So the Supreme Court left open the door to constitutional challenges to permitting schemes that are designed with abusive ends. Wait times is an example they gave. They also gave another example of the cost of getting the license. And they said those are examples, not the only way. The reason why I bring this up is this. We know that federal courts have taken over prisons that have misbehaved and violated constitutional rights under, for example, the 8th Amendment cruel and unusual clause, cruel and unusual punishment clause. We know that, for example, in Kansas City, Missouri, the school district out there for many decades, literally for decades, as I recall, for many years, I think actually decades, was taken over by a judge in the Western District of Missouri, federal court out there, and had to run a bunch of decisions by it because he concluded that a lot of the behaviors in the school district was illegal or unconstitutional, as that judge saw it. So here's my idea. If licensing divisions in places like New York, New Jersey, and California, if the licensing divisions harass and mess around with gun owners that are trying to get their carry permits in a shall issue carry regime, and these licensing divisions misbehave and constantly violate various types of civil rights and constitutional rights and Second Amendment rights, I would urge the lawyers out there, many of whom may watch this video and watch my channel, I don't know, but I assume some do. I would urge the lawyers and organizations out there that do Second Amendment litigations and do Second Amendment work, contemplate the notion of having a federal court take over a rogue licensing division to make sure that the people working in those licensing divisions, to the extent they violate the Second Amendment, behave. Because there's really no difference in taking over a licensing division that is not respecting and honoring the right to keep and bear arms from the federal court's point of view than it is for a federal court to take over a prison that refuses to respect, for example, the 8th Amendment's prohibitions against cruel and unusual punishments. Or to take over a school district, perhaps, that is not operating properly and thus is denying their students their right to a proper education, or is discriminating among the different students within that school district, let's say, and perhaps a violation of the 14th Amendment's Equal Protection Clause. So while I haven't analyzed every single possible detail, it seems to me there's really no intellectual, logical, or legal reason why a federal court, if they uncover a shall issue state or local or city licensing regime not following the text, the history, and the traditions of the Second Amendment and not doing what they should be doing under the Second Amendment, I see no reason why a federal court could not take over, put into receivership, or otherwise require that the people running, let's say, the licensing division have to report every month or so to the federal court to ensure that the rights of the Americans subject to the shall issue regime or that licensing division or that licensing department or that licensing office are having their rights respected and honored. So again, I'm thinking about doing something more of this, maybe doing a law review piece or something along these lines. But again, I want to share this idea with the people in the Second Amendment space. Okay, folks, I hope you've enjoyed this little lesson and little thought about institutional reform litigation and how it might apply to the right to keep and bear arms and licensing divisions that issue permits for the purposes of carrying guns outside the home, consistent with INSTITUTIONAL versus Bruen. And if you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.